For Ajax Pickering.
Well, thank you, Madam Speaker, and I appreciate the opportunity to rise and speak on this bill. I'm deeply concerned that any time the Conservatives are faced with a choice in a difficult situation to carefully consider policy and to sit down and have a rational discussion or to play politics, they choose politics. There doesn't seem to be a headline the Conservatives aren't willing to exploit. I can remember on the pardon issue that 4 or 5 years ago, the then Public Safety Minister said, after a sensational case, that they had fixed the problem. They had fixed the problem when it came to pardons. And he said you didn't need to involve the rest of Parliament. It was something they were able to do on their own. They refused to have any hearings. And on the back of the napkin, they whipped something up and they said, fixed, done. And then we had Grant James. And then all of a sudden, renewed, feigned indignation. We've got to do something. This is horrible. It's something that has to be done urgently. Of course, for totally forgetting the fact that they had themselves said they had fixed the problem some 4 years prior. But that didn't stop them from trying to play games with it again, ratchet up the rhetoric, and on the back of a napkin, whip up a policy instead of sitting down in a careful, considerate manner with Parliament and having a mature debate. And so it was when the Sun Sea and the Ocean Lady arrived at Canadian shores. The Minister of Public Safety was very eager, jumping at the opportunity to say this is a boat full of terrorists. He talked about intercepting boats in international waters, despite it not only violating international conventions, but anywhere else it's been tried, it was a complete disaster. Sometimes the fear being that people would be just thrown overboard to hide the evidence. Human beings tossed like luggage off the side of the ship to hide the fact that they were ever being smuggled. And so for roughly 2% of the claimants that would happen in a year, the Conservative government went nuclear. Not because they wanted to fix something, but because they wanted to play politics and saw a great opportunity to divide a wedge. Of course, those people they called terrorists turned out largely to be women and children, but that's an aside. Apparently didn't matter much to them. So after they floundered around talking about maybe going out into international waters or throwing around a lot of rhetoric, eventually we get this bill. Madam Speaker, I've got a lot of problems with this bill, and I'm going to go through them. But let me start with the fact that it's tough in all the wrong ways. It's extremely tough on claimants. It's extremely not tough and really doesn't change much at all for the scum and the villainy that prey upon the weak and smuggle others into this country. And so because it has that misplaced focus, I've got a real concern about how it's going to be effective. I think as well we have to look at the fact that this government is really masking the fact that the real solution rests in engaging international partners. If there's one thing this government hasn't been able to do with very much success, it's work with other countries around the world. If you want to go after the people that prey on the weak, that prey on those that are vulnerable, then you have to work with foreign jurisdictions and make sure you go after these scum in the place where they're doing it. Instead of being hard on the women and children who are trying to escape war-torn regions where they're fearful of their life, you got to go after the people who are preying on them, trying to suck money out of them, take advantage out of their unfortunate situation, stick them on dangerous ships, and send them across oceans here to Canada. You have to stop the problem long before they actually walk into that boat and begin their journey across the seas. And in this regard and in many others, this is just placebo policy, and I wish it was just that. But the government also plays upon misunderstandings between the word refugee, immigrant, claimant, trying to mix them all up together, try to confuse people, making them think that there's some queue that people are jumping, that somehow these individuals who are these claimants are jumping ahead of other people. The government knows this is false, and that's what makes the assertion so absolutely irresponsible and reprehensible. The government's job is to inform the public, to inform public debate, to inform it with facts, and to have an honest debate and discussion about the differences between political parties. But to capitalize on misunderstandings, to play games with let's be straight here, fake emails that go around with misinformation, and to write policy for misinformation and fake emails so you can play some grand political game instead of having an honest debate, I think is shameful. But it's not just me who's saying these things or having these problems with these bills. I'm going to, for a minute, if I can, Madam Speaker, just read a couple of things that some experts in these areas have been saying. And I think their words are worth hearing because they make the case so clearly. In a piece written for the Globe and Mail by Lauren Waldman and Audrey Macklin, entitled "Why We Can't Turn Away the Tamil Ships," she says, and I'll quote several excerpts from it if I could, quote, "Asylum seekers on boats is not a new phenomenon. In 1939, the St. Louis, filled with hundreds of refugees fleeing the Nazis, was turned away from Canada. At the time, the government tried to discredit the passengers as frauds and economic opportunists, and warned that if the St. Louis was permitted to dock, more Jews in Europe might follow. The line must be drawn somewhere, and it was drawn at zero. Many of the people on board subsequently perished in death camps. In 1969, Canada signed the Refugee Convention and undertook not to return refugees if they had a valid fear of persecution. This obligation is part of our law. Once asylum seekers reach our territorial waters and they are in Canada, they could not be sent back to another country unless their claims for protection have been denied. From the St. Louis onward, every new boat is accompanied by the denunciation of the passengers as frauds and dire warnings of waves. Yet 2 boats, one filled with Tamils and the other with Sikhs, arrived in the 1980s, followed by 4 boats with Chinese in the 1990s. And the sky did not fall in. All were given due process without creating havoc. Some were found to be refugees, some not. Other countries, including Australia and the United States, receive far more seaborne migrants than Canada, and far more irregular migrants in general. They go on to talk about the bill and say, moreover, such a regime would run afoul of our charter. Our Supreme Court has held that Canada cannot be directly or indirectly complicit in torture or other human rights violations. By turning away boats without fairly determining whether those on board would be at risk, we would be violating refugees' right to life and security of person. The article concludes, Madam Speaker, by saying Canada receives about 300,000 claimants each year. 500 Tamils represent only 2% of the annual intake. The rest arrive by plane or overland, so don't elicit the same moral panic as people on boats. Although the system has experienced delays in recent times, it has managed to provide reasonable, fair determination. Failed claimants are being deported each year in record numbers. All this to say that with a just and efficient determination system, we will be able to deal with asylum seekers arriving by boat or otherwise. And the best way, indeed the only way, to stop any future boats from Sri Lanka is by solving the problems in Sri Lanka. Amnesty International is also speaking in deep concern of this bill, saying that the proposal violates 3 treaties. They're saying that it violates the 1951 Refugee Convention, the International Covenant on Civil Protection and Rights, and the Convention on the Rights of the Child. They say it shows no respect for equality provisions in the Charter of Rights and Freedoms. And they say, quote, and this is from Amnesty's Gloria Nafziger, quote, "It's a flagrant violation of so many rights. It just goes beyond the pale. Those treaties are international treaties we signed on to, and we have an obligation to uphold and respect them." From other stakeholders, from the Canadian Council of Refugees, they were saying that despite the government's claim that it's targeting smugglers, the people who will suffer in this bill are the people fleeing persecution, including women and children. They assert that measures keeping some refugees longer in detention, denying them family reunification, and restricting their freedom of movement are likely in violation of our charter. Professors like Peter Schauler say that, and this is the former head of the IRB and immigration, he's also a refugee expert, has noted that there are 2 different targets under this bill: the human smugglers and the refugee claimants themselves. Even if a person is accepted as a refugee, which means they fear persecution for 5 years, they can't bring their family members. Well, this isn't just any family members. We're talking about husbands, wives, and children who are trapped in conflict zones. Mr. Schouler has characterized many of the provisions in the bill as outrageous. So what I would like to do, Madam Speaker, is talk about some of the specific provisions that this bill does undertake. One of the much heralded things that this bill does is it creates mandatory minimums. It defines aggravating factors where those mandatory minimums would be triggered. So there's two aggravating factors. Factor one is where somebody is engaged in the activity for profit or whether or not they're with a criminal organization. And factor two is whether or not it endangers the life of a person who's being smuggled. And they get into this formula where you say if you've got less than 50 people and you have one aggravating factor, it's a 3-year mandatory minimum. If you have both aggravating factors and it's under 50, then you've got a 5-year mandatory minimum. If it's more than 50 people, you have a mandatory minimum of 5 years if it's one aggravating factor, and you have 10 years if it's 2 aggravating factors and more than 50 people. Yeah. Well, here's the problem, Madam Speaker. The current penalty is already can be up to life imprisonment and $1 million fine for anybody smuggling somebody more than 10 people. So you already have extremely serious measures that the government can use at its disposal that are already on the books to go after these smugglers. So these mandatory minimums are a placebo. They're held in the window to feign action, to pretend they're being tough, as they like to say, when in reality they're little more than window dressing, when in fact the actual tools that they need are already in place to go after the smugglers. The problem is they're not going after them where they need to, overseas, in other countries, working with other jurisdictions. There are some provisions of this bill that I think we could support, looking at increasing penalties under the Marine Transportation Act for somebody who is providing misleading information, or somebody who who failure to comply with a ministerial order and therefore would be refused from entry. But one of the things that I think is very concerning, because its wording is so ambiguous, first was introduced by the minister when he talked of a, quote, human smuggling event. And all of a sudden this human smuggling event would trigger all sorts of extraordinary powers. We're not given any details of what those powers would be or how they would be exercised. But eagerly, obviously, we looked at the bill and tried to determine what those powers were. Gone was the term human smuggling event, and now came the term irregular arrival. Now, irregular arrival has no real specificity, and in fact could just be 2 people, not a large group or some throng of people hoarding into Canada, but it could be 2 people. And if the minister, for whatever arbitrary reason he or she decides, invokes this provision, you suddenly have 2 classes of refugees, those that are subject to one set of rules and those that are subject to another. And it could be for no other reason other than the minister doesn't happen to like those particular refugees, or happens to think one particular group coming from one particular region is more disliked by the public, and therefore maybe we should play games with them and play it for wedge politics. And the problem here is that for that separate class, you invoke some very different rules. One of them is you would invoke mandatory detention, so that when somebody was defined in this class, they would be detained for a minimum of 1 year. This mandatory detention then would not be reviewed again for every 6 months. So you can imagine women or children being in a detention center where they're only given the opportunity once every 6 months after the first year to appeal that detention. And while they're detained, it stops their ability to appeal to a refugee appeal division. It stops their ability from making any claim on humanitarian or compassionate grounds for their situation for 5 years.